Next case on the docket is the COSTA case. May it please the court and counsel. I'm Attorney Paul Schaefer. I represent Philip Costa, the appellant here. I think the main issue here is whether or not the trial court erred in granting a summary judgment saying...
Mr. Schaefer, did you file a reply brief?
No, Your Honor.
Okay. I'd be interested in hearing what your reply is to counsel's argument that this is really contract law here, that the court's bound by the contract between the parties, and the contract says, you know, non-modifiable unless there's remarriage or death. What do you say about that?
Well, Your Honor, what I say about that is even the court here has found that in certain circumstances there can be a de facto marriage, meaning a supportive relationship exists between the two cohabitators to the extent that the alimony obligee is...
So you want us to construe the contract so that remarriage means something other than a legal marriage?
Yes, Your Honor, and I think that's what 61.14 states. It's just a codification of prior case law that says that.
I know all about I understand your argument about the statute and the case law and all that, but you know, counsel's argument is that we're dealing with a contract here, first and foremost, and the contract says it's not alimony is not modifiable unless there's remarriage.
But it does say it can be terminated by remarriage or death.
That's why I said it's modifiable unless remarriage. The contract says it's not, alimony is not modifiable, but it says that it is terminated upon remarriage or death.
Yes, Your Honor.
All right. So, you know, that's the contract that the parties wrote. And remarriage does not seem to me to be an ambiguous term. Why shouldn't the court, why isn't it our responsibility to enforce the contract?
Because the contract cannot override case law or statutory law.
It can't. Sure it can. I mean, counsel cited a case in his brief that where the third district, I can't remember the name of the case, but the third district said that not only can we not, you know, can it overrule all that, but you could waive any statutory or constitutional right that you have in a contract, and that the court is obligated to enforce the contract. Isn't that the situation here?
Well, the situation is, Your Honor, as this court has ruled on numerous times that you can have a de facto marriage, and I can cite the court.
Were those cases with a contract that said that it was not, alimony was not modifiable?
I'm unsure on that, Your Honor.
You could have entered into a contract that said it's non-modifiable even in the case of remarriage, correct? And that would be enforceable. Somebody could agree as part of a divorce to pay alimony to their former spouse for the rest of their life even if they remarry, correct? As a matter of contract.
Yeah, I believe that's the case, Your Honor.
So it wouldn't, and that's the case, the contract would control over a specific statute which says alimony ends upon remarriage, correct?
Right, but that's not the case we have here.
No, but we have a contract, so, I mean, the first principle is, by contract, you can agree to something other than what the statute calls for, correct?
That's correct.
Okay. So then we get to whether or not under this contract it can be terminated, not under the case law, under the statutory interpretation. Would you agree with that?
Well, I'd agree, except to the extent that this court has defined what a marriage is, and this court has said that a marriage doesn't have to be a legal marriage, it can be a de facto marriage.
Well, the question here is what was the intent of the parties when they made reference to a remarriage, correct? If we're going to do it as a matter of contract law, it seems to me you've got a two-step process. One, you have to convince the court that the term remarriage is ambiguous. And if you convince us that it's ambiguous, then you have to show that there's some parole evidence out there to show that the intent of the parties at the time they signed the contract was that remarriage meant something other than a legal marriage.
And that's the problem with what happened in this case, Your Honor.
It
There was a summary judgment hearing. There was absolutely no discovery done, or there was discovery attempted to be done by myself, but there was no response. There was no
Did you move to continue the hearing because discovery was not complete and therefore it was premature to hold the summary judgment hearing?
No, Your Honor, because there was no...
It's my understanding of the law, then you can't complain about the inadequacy of the discovery because the remedy for that is you move to continue the hearing.
Well, there was no evidence, legally sufficient evidence at all submitted by the former wife's attorney. So with no evidence submitted, no affidavits, nothing, the court had nothing except
But
for
wasn't there
legal-
evidence that here's the contract and she didn't remarry? Was that in the record?
That was probably it.
Isn't that enough? You got a contract that says it continues unless I remarry and I didn't remarry. End of story.
There's also evidence that your client knew that she was living with Mr. Brown at the time that they entered into the contract.
Your Honor, he knew that, but he was informed that it was a different relationship than it turned out to be after they divorced, and then as put into my petition for supplemental modification of the final judgment, it shows that at the time she was a receptionist at this private school where her cohabitator was the administrator, and then after the divorce, he turned over the private school to her, and that was one of the substantial changes that occurred. Also, he was under the impression that this was just a situation where she was renting a room from this person, and that was it. In fact, the thing that's interesting, if you look at the first paragraph of the appellee's brief, it's right in there. It says the former wife decided to rent a room in Mark Brown's home for $500 per month. That's provided in her financial affidavit dated October 19th, 1999. So she puts in her financial affidavit shortly before they get divorced that all she is doing is renting a room from this individual, and after the divorce, things change, and a lot more happens, and as explained in my supplemental petition, and therefore, my client was under the impression that the only thing that she was doing was renting a room from this individual. In fact, he was led to believe that she was on the waiting list for an apartment. I think that's all in the argument and the summary final judgment. And also, if we went to trial, we would have the opportunity to present witnesses that would testify that they were told by this Mr. Brown also that she was getting her own apartment, and this was just a temporary situation. And it was not a cohabitation situation where there was an economic support equivalent to a marriage, which turned out later to be the case.
Did you present an affidavit or any evidence of record as to the intent of the parties for what they meant by the term remarriage?
No, Your Honor, but I believe that a motion for summary judgment, the movement has the burden, and I don't think that anything they presented met even any close to the burden of showing that there was no irredisputable facts, which they didn't.
What did they need to prove other than the contract says it continues unless remarriage and I'm not remarried? Why doesn't that meet their standard?
Because, Your Honor, like I said, I believe the law is that if there is a supportive relationship that's equivalent to a marriage, that the court can interpret that as a marriage.
That's not a matter of contract law. You have a contract that says remarriage is the factor. They presented evidence that they weren't remarried. Why isn't that enough?
Your Honor, all I could do is restate what I just stated.
Do you think that the statute applies retroactively?
Do I think it applies to this situation where it's our understanding that the the alimony obligee is still living with the cohabitator, yes, I do, because we're not asking it to be applied retroactively to terminate at a prior date, prior to the statute coming into effect. So in essence, he would be getting credit for the alimony going back. That's not what we asked for. We asked for it to be terminated as of the date of the filing of our pleading, which was July 1st, 2005. The statute came into effect in
Well,
June of
the
2005.
supportive relationship apparently started before the statute's effective.
Yes, Your Honor, I understand that.
So you know, do you think that it's appropriate to apply the statute to conduct that preceded the date that the statute was enacted?
Do I believe it's appropriate where the conduct is still continuing at the time the statute comes into effect? Yes, Your Honor, I do. I'd like to go on to state that I think that if you read the record, I think that if you're going to take the record of the motion for summary judgment hearing, that both sides agreed that an economic supporting relationship existed at the time the supplemental petition was filed, and therefore there was a factual issue as to whether when this economic support relationship came into effect. As stated by the appellee, they state that it occurred prior to the final judgment of divorce. We have evidence, if it proceeded to a trial, and like I stated before, a summary judgment hearing is not supposed to be a trial, that we would show that this came into effect afterwards. And I again remind the court that even in the appellee's brief, they state that she was renting a room for $500 per month, as stated in her financial affidavit on October 19, 1999. So this economic support relationship did not come into effect until sometime after the final judgment of dissolution of marriage.
Did the husband have counsel at the time of the marital settlement agreement?
Yes, Your Honor.
Because my question, I mean, could it very easily have been dealt with in the marital settlement? If the husband's intent was that it should end if there is a supportive financial relationship, it could very easily have been written into the contract, couldn't it?
Well, Your Honor, my answer to that would be that my client was assured by his wife at the time that this was not a cohabitation type situation.
Well, but if his intent was if she ever entered into one of those kind of relationships, the alimony should end, even if she wasn't in one then. Because you've got to, I think you've got to convince the court that the intent of the parties at the time the contract was entered into was to cover those kind of not legal marriages. So it really doesn't make a difference what was occurring at that point in time. If his intent was if it ever happened in the future, he wanted the alimony to stop, then he could have written it into the contract, right?
Well, Your Honor, you know, I will point out 61.14, the new law. There's nothing in that new law that says that in a marital settlement agreement it has to be written into the marital settlement agreement in order for that to apply. So I would disagree. I would state that that marriage has to be interpreted according to what the case law says and according to what the statute says what a marriage is. And the court has ruled that a marriage can be something more than a legal marriage in deciding whether or not to terminate alimony.
So it's not, as I understand your argument then, it's not that that was his intent at the time he entered into the contract. It's that he thinks he can get the benefit of a later change in the statute that defines marriage? Is that your position?
No, Your Honor, that's not my position.
So it's your position that at the time he signed this contract, he intended that alimony would stop if his ex-spouse entered into a supportive relationship with somebody else?
Yes, Your Honor.
All right. But there was no evidence presented of that, and it's your position you didn't have to because it was summary judgment, correct?
that there was no evidence, legally sufficient evidence presented by the former wife to her attorney, so therefore there was no legally sufficient evidence that I had to rebut at the summary judgment hearing. That's correct.
If it's your position that that was his intent at the time he entered into the contract, what's the relevance of the subsequent statutory amendment? Seems to me that wouldn't make any difference. Whether the statute was ever amended or not, you'd have the exact same argument, wouldn't you?
Well, that's correct, Your Honor. It just bolsters the argument that this statute is now in effect.
Mr. Schaefer, can I ask you a question?
Sure.
Let's say hypothetically that the marital settlement agreement that was incorporated into the final judgment said that alimony is not modifiable. It can only be terminated on remarriage or death, and that does not, remarriage does not include a supportive relationship. So it was explicit about that particular point. Does this statute that is enacted in 2005 have bearing on that contract if the contract was executed prior to the enactment of the statute?
If there was an explicit waiver that both parties agreed that an economic supportive relationship would not be considered in considering whether or not alimony should be terminated, then yes, I think that would probably override the statute.
The statute can't be used retroactively to abrogate the rights under the contract.
If it was explicit in the statute that both parties were waiving that provision, I believe so.
We've got a little under 4 minutes.
Yes, Your Honor. I'd like to reserve time if I could. Thank you.
Hey, please, the court and counsel. My name is Richard Mamley. I'm attorney for Marty BAHILF, the former wife in this case. Back in 2000, the parties decided they wouldn't take any chances. They didn't want to deal with future need or ability to pay.
Well, do you think this statute applies?
Judge Perry said that it shouldn't be applied except prospectively, and I believe he meant, although he didn't say so, from the date of new final judgments as of June of 2005 forward. If that's what Judge Perry meant, then that's why he took the position that it doesn't apply retroactively.
So you don't think the statute applies? I'm asking. I'm asking.
I think it's intended to apply retroactively, but that's not the rule of the court, trial judge in this case.
Mm-hmm. Or is that, I understand your contract argument, and the contract does say that alimony can't be modified, but the contract also says that alimony shall be terminated upon remarriage, and now we have a statute that essentially equates a supportive relationship with a remarriage.
I don't believe that's true, Judge. I think that this 6114 is an economic supportive statute that has nothing to do with de facto marriages or, as counsel would point out, anything other than need. This statute, as the court has pointed out, goes to codifying guidelines that the courts have previously given on factors regarding cohabitation and or supportive relationship, all going to a singular issue, and that is, has the former wife's need changed since the final judgment? And that's what counsel is asking to do in this case, is have the court now address an issue regarding the former wife's change in circumstances. They waived that when they decided to do non-modifiable alimony. This is not a permanent alimony case. This is a non-modifiable alimony case. 6114 goes specifically to alimony that's not non-modifiable. I think the legislature probably used the word alimony instead of permanent alimony because often we see in the MSAs, or the courts will say alimony, and they won't use that word permanent in front of it, but then they will give alimony until remarriage or death. And so in this case, the court's pretty clear in holding in Turner that you have a right to waive a modification, and that's what the former husband did. So it was the court's...
What does this mean right here, this statute, a supportive relationship? Is that defined in the statute?
only to the extent they use the words, and then they give some guideline factors in considering what the court should look at.
Oh, I mean, in other words,
A need.
if the payee spouse takes on a roommate that is paying part of the rent, is that a supportive relationship?
It very well may be. It all depends on how it impacts her ability to support herself.
So you're saying a supportive relationship is not the same as a de facto marriage?
No, Your Honor, I think that the courts may find under the statute, even if there is nothing more than a platonic relationship between two people, but one of them happens to have a yacht and a boat and can start supplying a large home to the benefit of the other spouse of the former obligee, that they don't have the needs that they had at the time of the marriage, that the statute could kick in.
It just gives the trial, it just lets the trial judge know what the trial judge really already had before, which is the discretion to modify based on need and ability to pay.
Right, and just to increase some of the factors and gave some more of the guidelines. The Turner case stands for the proposition there's no public policy preventing the waiver of modifiable alimony. And in fact, in the Porter case that I cited, the court said where an MSA fails to make provision for unmarried cohabitation, that may be interpreted as precluding reduction of alimony on that ground. Here, unlike most cases, the former husband had the opportunity to know that his wife was in a situation where she was living in the home of another man, so cohabitation issues had to be going off in his head, and he had the opportunity to address that and say, you know what, I want to address this now. I don't want to take any chances on your word, if that's what the counsel's proffering here, that, this is just a temporary situation. Let's go ahead and put it in here. But the courts are pretty clear.
His knowledge about that relationship, how is that demonstrated in the record?
Only by proffer of counsel. I wasn't the trial counsel at that time, but having read the record, I see it's only proffered by counsel for the former husband. This is what the testimony would be.
So, proffered at the hearing below.
That's correct, Your Honor. And so, in short, Judge Perry hit it on the head. He said, non-modifiable means non-modifiable. You're not free to pick and choose what is non-modifiable and what's not. And that's what occurred here. They both agreed that as to the issues of need and his ability to pay, which parenthetically, Your Honors, he pled in the supplemental petition to modify not only the need of the wife in 6114, but then he comes in and says, oh, also his ability to pay has a decrease, which again flies in the face of their agreement, which is this contract said non-modifiable, and that's what it meant. Thank you, Your Honor, with the reserve.
Thank you, Your Honor.
Let me follow up on Judge Torpy's question. What is your understanding of a supportive relationship? If an ex-spouse moves in with a parent who's providing financial support, is that a supportive relationship which could be used to modify alimony?
No, Your Honor. I could go through all the things that are laid out pretty clearly in 62.14, and those would be my idea of what a supportive relationship is, which would include holding yourself out as a married couple, where one, the obligee is actually being supported economically by the other cohabitator, which we would say that if we went to trial, we could show facts that in this case, a business was turned over, this private school was turned over to the obligee by the cohabitator, in showing that there was a marital situation where he was turning over a business to her. I mean, these are all the factors, or some of the factors, I apologize, I don't have them all memorized, that are in 61.14, but I believe 61.14 does lay out where an economic supportive relationship exists. Now, again, if we went to trial, it would be, our obligation to prove by a preponderance of the evidence that these factors, or amongst these factors, were met, and then a trial court has to make specific findings as to if an economic supportive relationship exists and how it complies with the statute. Turner, I just wanted to summarize that I believe, and maybe my hearing was wrong, that Appelli argued that this wasn't a permanent alimony situation. But if you look at the final judgment, paragraph 1, it says the husband shall pay to wife the sum of $1,000 per month as permanent alimony commencing on the first day of the first month following the execution of this agreement. It states right in the contract this is a permanent alimony situation. So I would argue that that's not the case. Let me just, in my few minutes left here, Your Honor, let me just cite back to a couple rulings this court has made. When two people of the opposite sex reside together, a de facto marriage exists, and the law should not discriminate between a de facto marriage and a legal marriage. And that's Lowry versus Lowry, 512 Southern 2nd, 1142, 50 CA, 1987, clearly predating this final judgment, Your Honor. When alimony is for support and support has been undertaken by another, alimony can be terminated, and that's another 50 CA case, Benzini versus Benzoni, 442 Southern 2nd, 235, 238, and again, that's a 1983 case. Again,
Any of those cases involve a contract that says it's not modifiable?
Your Honor, I believe one of the other jurists asked me that question, and I can't answer it. Your Honor, I would conclude by saying that Chapter 2005-168, Florida Statute 61.14, merely codifies prior case law that a de facto marriage is a valid reason to terminate alimony, and a de facto marriage should be treated the same as a legal marriage in determining when to terminate alimony. Thank you.
Thank you, counsel. We'll take our morning break at this point. Counsel's invited to join us in the attorney's lounge.